Welcome to the Real Estate Syndication Show. Whether you are a seasoned investor or building a new real estate business, this is the show for you. Whitney Sewell talks to top experts in the business. Our goal is to help you master real estate syndication. And now your host, Whitney Sewell.
This is your daily real estate syndication show. I'm your host, Whitney Sewell. Today, our guest is Amy Wan. Thanks for being on the show again, Amy.
Yeah, thanks for having me again.
Amy was the previous guest, so you've probably heard her name, and if you haven't heard her already, you heard her on the show WS146, and we're very grateful to have her back to really dig into some of these, what some people refer to as boring, but they're so important. I mean, it's such a critical part of this business, and it's important that we know all these details of the legal ramification laws and regulations that are so important to our business. And so, but you know, I want you to still know she's the founder and CEO of Bootstrap Legal. She's authored LexisNexis Private Equity Practice Guide, and she was named one of 10 women to watch in legal technology by American Bar Association Journal in 2014. And Amy, again, thanks again for being on the show and helping us all understand. You know, really, it's it seems very complicated stuff. You know, it's like it's intimidating, right? When people get into this business and people avoid the syndication business, it seems sometimes because of, it's just too complicated, you know?
I totally get it. I mean, look, when I was first learning this stuff myself, when I, just started practicing securities laws, I was like, oh my gosh, I can't get the difference between Title II and III and 506B and C, and they all sound the same, right? And it's like, when do you use them, when, right? And I think it's just, I think it's harder for issuers, for real estate syndicators to get their hands around it when, they only encounter it once in a while versus, having been an attorney and worked with so many different clients of all different types, you start seeing a lot of different patterns, right? And so what I find most often is that people will call me saying, hey, I want to do a regulation blank offering. And I ask them a couple questions. I'm like, okay, well, you should not do what you called me to do. You should do something else instead, right? It's gonna work better for you. The way your business is set up right now, all that kind of stuff. It's just it's gonna be a much harder road for you if you use the one you called about versus the one I'm suggesting. So a lot of this, like it's very much an art, but it's also a science.
Okay. Well, I'm ready to dive in, and we're going to do, just so the listener knows, we're going to do a series of shows, and we're going to talk about different aspects of the legal side that we need to know, and Amy's going to help us to understand. But today we're going to focus on just the laws and regs around raising capital and Reg D, Reg C, all these reg letters that we hear that we don't really understand. We just have to we trust our teammate, our attorney, to help us and guide us, somebody just like Amy. So, Amy, get us started. And as we talked about, I think a good place to start is, knowing the exact difference between accredited, non-accredited investors. And then we're going to get into why that's important to know.
Sure. Fantastic. So everything that we're talking about today, we're talking about when folks are raising private capital. When I say private capital, it means they are not going to, doing an IPO. They're not going to the New York Stock Exchange. They're not raising publicly from the public, right? So in the world of private capital markets, there's this concept called an accredited investor. An accredited investor, in the most basic terms, it's just a rich person. That's really all you need to know, right? It does get more technical than that. So the technical definition of an accredited investor is, someone who has an annual salary of $200,000 or more if they file their taxes singly, or $300,000 more if they file jointly. Or from a net worth perspective, they have more than $1 million in net worth, excluding their primary residence, right? So we're talking about, whatever might be counted as an asset or a liability on their mortgage. But for the intent and purposes of this podcast, all you really have to know is that they are a rich person and that there are different ways to verify whether or not they're a rich person.
Now, I wanted to ask, do they have to have that income for a certain amount of years, or is it just like right now?
Yes, the past 2 calendar years. So if it's like the middle of 2019, well, 2019 doesn't count. It has to be 2018 and 2017, right? So it almost actually sounds like 2.5 years, but it's just the past 2 calendar years.
Okay.
Yeah.
Okay. So that's an accredited investor. And, do I have to, I was going to say, do I have to verify that? But I think we'll get into that in a minute.
Yes.
We'll get into that in a minute when we talk about some other stuff. But so non-accredited versus accredited. I mean, if they're non-accredited, that just means they didn't meet that standard. Is there any other type of investor that we need to know about? Sometimes they're called sophisticated or,
Yes. So, we just talked about accredited investors. If we're talking about non-accredited investors, so people who don't meet those benchmark numbers set by the SEC, then they're considered a non-accredited investor, right? And so in the bucket of non-accredited investors, there is something that we call a sophisticated investor. And a sophisticated investor, all it really is someone that, tends to be a little bit more financially savvy. They understand what they're investing in and the risks of what they're investing in, right? So the sophisticated investor comes into play when we're talking about Rule 506B. And when we talk about the sophisticated investor, we say that you have to have a pre-existing relationship with them, right? So what a pre-existing relationship means is and there's different definitions and interpretations, right? The most classic, I would say, is that you already knew them, right? So it's not some random, email list that you bought off of someone that you've never talked to anyone on that list. It's not your email list where it's, half of them are random people that come to your website that you've never talked to, and the other half are people you actually have had some sort of conversation with. This really ends up being someone that maybe you've sat down and had coffee with. Maybe you had 2 phone conversations with them. Maybe in addition to those conversations, you had them take a survey about, what kind of investment opportunities they're interested in, how much they have to invest, things of that sort. There is a whole art towards making sure that someone is a pre-existing someone actually does have a pre-existing relationship with you. I have some syndicator clients who they'll use their website to bring in folks, but then everyone who signs up for a newsletter on that website, they will make them take a survey. They call them up twice. And once those 2 or 3 steps happen, then they count that person as having a pre-existing relationship with them, and they're the ones who get sent deals. Everyone else, they just get general newsletters. You don't touch them for the purposes of soliciting investments.
Are you tired of answering emails from investors about when they'll receive their K-1s? Let the real estate CPA handle the accounting and taxes on your next syndication, and they'll file your tax returns by March 15th so you can get your K-1s to your investors by the individual filing deadline on April 15th. Not only will this reduce headaches, but it will help you retain investors over the long term by improving investor experience. The Real Estate CPA is now offering a special virtual workshop to the listeners of the Real Estate Syndication Show on how to answer tax-related questions from your investors. Learn more today by visiting therealestatecpa.com/syndication.
So a couple questions for you. Recently I heard someone talking about if this pre-existing relationship is a big deal, right? And it's a big deal that you track this, or that you can show that you had a pre-existing relationship. When you say, Amy,
it is and it isn't, right? Like the chances of the SEC coming to actually audit you are not high, right? Depending on what you're doing. But if they do actually come audit you, they may ask to see proof or documentation that you did have a pre-existing relationship with your non-accredited investors. And if that's the case, it's kind of like, the IRS coming along for tax auditing. You better have that documentation or that proof.
So and maybe even this past weekend at a conference, someone was talking about, like, they have a Google form that they'll have someone fill out. So like if they go on their website and they say, yeah, I'm an accredited investor, it automatically send them this form that asks them specific questions. And if they fill that out, then they consider them an investor, even though, like, they won't have a conversation with them. And I wondered, is that a pre-existing relationship? I do know these things. Like, okay, I know, maybe they've invested passively before, or, they have this net worth, or, whatever. But I've never had a conversation with them. Is that okay?
So, the SEC does not really come out and say, okay, like, these are the steps you have to take to make sure that you have a pre-existing relationship with your investors, right? They will put out guidance, but it really is a very gray area. And so I tell people, if you're going to operate in the gray, you kind of want to make sure you're, not quite in the middle, but towards, somewhere that's a little bit safer. So, if it's just a little extra work to go and, at least have a 5-10 minute conversation with one of these investors, I would say, why not? Right. And honestly, it's not that hard, because let's say, because at the end of the day, when it comes down to real estate syndication, it doesn't matter what you're doing, right? The most important thing is that you establish trust with your investors, and trust is a very personal thing. If you're just going to willy-nilly take, capital from people you've never had a conversation with, I just don't think that's generally a great idea. Like, you definitely want that personal rapport. So even if it's not like a legal requirement, it's something you kind of want to do anyway.
Yes. Yeah, I agree. And one other question about that, what about referrals? So let's say I put an offering out. Okay. So now all of a sudden, anybody that invests in this deal, I had to have a pre-existing relationship with, right? But let's say, a current investor sends that to a friend of theirs, and then now that person wants to invest in that offering, in that deal. Is that, I've never met that person before, but I had heard reference before, like, you can base it off the individual that you do know, and their history with that person. But I don't know. I just felt a little uneasy about that.
Right. So for broker dealers, they can do that, and they can present an offering to someone that the issuer, has not had a pre-existing relationship with ever, right? And just sell that deal to them. When it comes to the issuer, this happens all the time in the investment industry. It's like, so-and-so is making a great return. And they tell their friends about it, and their friends are like, oh, can you connect me with that person? I want to invest too, right? So you definitely can do that, but, and of course, you should consult your attorney, and how you do it, you should talk to your attorney about, but generally you can do that. And it happens all the time. I would just say, there's some ways that it shouldn't happen. Like, obviously you shouldn't go in front of a room of people and just try and start selling your offering, right? But if it's like through a friend of a friend or whatever, when they get referred over, you should try and establish a pre-existing relationship with them then.
Nice. Okay. So, we'll move on, but, Reg D rules 506B and C and those things, and everybody gets confused about. Tell us, why we need to know what those are.
Okay. So the first one that we're going to start off with is Regulation D. And under Regulation D, there are multiple rules. It used to be that there was only one Rule 506 that was, pre-2012. Now with the Jobs Act, there are different types of Rule 506s. So the one that's existed for many, many, many years, prior to even 2012, Right now it's called Rule 506B, B as in boy. And this one I would say is the most important rule for folks to know because, like not over 90% of private capital is raised under Rule 506B, right? So Rule 506B, it's pretty simple. And so when I'm explaining these rules, the one thing I want listeners to keep in mind is something I always say, what the SEC giveth, the SEC taketh away, right? So the more slack the SEC gives you in going out to raise capital, the more that they're going to ask for in return. So when it comes to Rule 506B, we can raise as much as we want, right? We can raise from accredited and non-accredited investors, right? It's near instantaneous. Like I don't have to go and ask the SEC for permission to do this type of offering. I do my legal paperwork. And after I've raised funds, then I go and I do a free filing with the SEC and, the different states. So it's not mother may I, it's, you just tell them later. What are they going to ask for us in return, right? So I said you can raise from accredited and non-accredited investors, but you can only raise from up to 35 non-accredited investors. And remember, these non-accredited investors must be sophisticated and you have to have a pre-existing relationship with them. So realistically, what it's really going to look like is you're primarily using accredited investors. And then you're probably letting in a couple of friends and family that happen to be non-accredited, right? Now, when your investors do come in, they have to self-certify that they are an accredited investor, right? And there's different ways to do that. Usually it's through the subscription agreement, which asks them all these different questions and asks them to say that they are accredited. Now, here's a tip. People lie. People always lie, especially on the internet, right? And so you should leave cushion room for that, right? If it turns out that one of the people who said that they were accredited actually wasn't, then that could potentially put you in hot water, especially if you go over the 35 limit. So I usually tell people, don't take exactly 35 non-accredited investors, take less than that, maybe half at most, right? And then the other thing that you have to be very aware of is Rule 506B is your very classic private capital raising exemption. So if you're raising privately, that means you should not be going out to do advertising or what we in like lawyer SEC speak, we say is general solicitation, right? And general solicitation is going out and telling about the offering to folks in a very non-targeted manner, advertising, right? So Rule 506B tends to work for almost any type of syndicator because, if you have really large deals, you're probably not going to want non-accrediteds in there anyway, right? And so you can go out and raise really large checks from investors for a very large offering. But at the same time, it's also very good for the person who's just starting off with real estate syndication. Maybe they want to do a sub $1 million raise, and so they really need to raise money from both their friends and family, but also go and find some accredited investors to throw into the mix, right? So it's a very good like catch-all type of rule for people to raise under. The next one is called Rule 56C. And prior to...
Could I ask you one question before you...
Yeah.
So, and you had referenced earlier about people lying about being accredited. And so, I know that there's got to be people that, I mean, I can't prove it, but they got it, under 506B where they self-certify, they sign saying they're accredited. And so if they're not accredited, I mean, how would I ever know? Or is that something that
you wouldn't? Is
that something I should even like waste time thinking about or worrying about? honestly.
No, I mean, the way I usually counsel my clients to do it is just, non-accredited investors, just don't take too many of them, right? So that you don't accidentally go over the 35 investor limit, because you're not going to want to, could you go and do more deep due diligence? Yes. Will your investor hate you for it? Yes. They're not going to want to show you all the paperwork and all that kind of stuff to prove that they're accredited, right? And unfortunately, the liability falls on the issuer, the syndicator. So I wouldn't waste too much time losing sleep over this. I would just not take too many non-accredited investors.
Okay.
Got it?
Got it.
Cool. All right. So the next one, Rule 56C as in cat. This one did not exist before the Jobs Act of 2012. And it first became available for use at the end of 2013. So it's very, very similar to Rule 56B that we just talked about. And if we could call this rule anything, I would call it accredited crowdfunding, right? Reason being, it's crowdfunding in the sense that you now can go and generally solicit and advertise, right? So go tweet and do LinkedIn and Facebook ads to your heart's content. Go shout it off from the top of rooftops, announce it at meetups, buy ads, social media, whatever you want, right? However, remember that what the SEC giveth, the SEC will asketh something in return. And so what they ask in return is now it's accredited investors only. You are not allowed to take those non-accredited 35 investors anymore. Every single person has to be accredited, and you actually have to verify their accredited status. So there are different ways you can take to verify, right? In the SEC world, this is somewhere where the SEC said, look, there's many different ways where you could verify that they're accredited. We will give you a few examples of ways that, if you follow these steps, you can be sure that we will never come after you because you took the right steps to verify that they were accredited. Everything else, we can't promise you that safe harbor. That's what we call it, a safe harbor. But it just has to be reasonable, right? And so the rule is you have to take reasonable steps to verify their accredited status. So things that you can do, you can have a CPA write a letter that the investor is accredited. You can have a broker dealer or an attorney write that letter, right? There are services out there such as Verify Investor, for example, where they basically have on-demand lawyers who will sign a letter stating that you're accredited. But obviously they're going to ask the investor to give over enough paperwork that they can actually verify that, right? So there's multiple ways you can get it done. And aside from those ways, there's other things that investors can show you, but if it doesn't fall on that list, then you just have to live with the uncertainty. All right, so for Rule 56C. So now we can advertise. We can't take non-accredited investors anymore, but we can still raise as much money as we want. It is also immediately available, right? So as soon as you have your legal docs or whatever you're doing, you can go out, raise the money, and then you don't ask Mother May I, you just go out, you raise the money, and then afterwards you come back and hopefully your attorney does what we call a Form D filing with the SEC and then state filings at the state level, right? So, and once I finish talking about all these rules, I'll come back and explain when people use them. But I'll make this note. A lot of people call me saying, hey, I want to do a 56C raise, right? In fact, I want to do all my raises as Rule 506C raises. That's not necessary, and a lot of times it's actually not advisable.
They're just thinking they want to be able to advertise to raise capital.
They think like, oh, if I build it, they will come, right? The crowdfunding field of dreams. But money doesn't necessarily, fall down from trees like that. And a lot of raising capital it's very psychological, right? It's all a game, right? And to do a 506C for every single one of your offerings is not the best way to optimize that game. And I'll talk about that after we finish going through all the rules.
I hope you are enjoying the show with Amy Wan. You will hear part 2 of this show tomorrow. She has a wealth of knowledge and just continued answering many questions that we all need to know in the syndication business. I hope you have joined the Facebook group, the Real Estate Syndication Show, and I hope you will go to Life Bridge Capital and connect with me as well. We will talk to you tomorrow.
Thank you for listening to the Real Estate Syndication Show, brought to you by Life Bridge Capital. Life Bridge Capital works with investors nationwide to invest in real estate, while also donating 50% of its profits to assist parents who are committing to adoption. Life Bridge Capital, making a difference, one investor and one child at a time. Connect online at www.lifebridgecapital.com for free material and videos to further your success.